Let me start with the basic fact behind all of this, that the current FBI director pled the fifth in the matter where he ended up providing grand jury testimony. We've never had an FBI director come through this committee who had pled the fifth before. As you know, when you plead the fifth, to do it honestly, you have to have a good faith belief that your testimony would subject you to criminal liability, which meant if Patel was being honest, he had a good faith belief that his testimony would subject him to criminal liability. As that went forward, he ended up getting immunity from the government in order to testify. If this were a court, a civil court, a judge would allow an adverse inference to be drawn against the witness who had asserted the fifth. In Patel's proceedings, we were never even allowed to get to the bottom of the grand jury testimony. Why he pled the fifth, what he said, all of that was papered over as he went through this committee to confirmation. So for obvious reasons, I pursued that question, just as you would, Chairman, if the shoe were on the other foot. And I believe that Patel lied to us in the committee. He said that he couldn't share his grand jury testimony, and I'm quoting him here, because there's a court order on that case. He said, he said again, I can't go into court orders granted by the DC District Chief Judge. And then when I pressed him further, he challenged me saying, you want me to violate a court order? He then went on to say to Senator Booker that his grand jury testimony has been sealed by the Department of Justice and I'm not allowed to discuss it here. Well, as it turns out, none of that was true. All of that was false. And we know that because the DC District Chief Judge, who he mentioned in his false statement to this committee, said, and I'm quoting the judge, July 2025, Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee, unquote. So it sure looks like he lied about that. So in his recent testimony, I asked him again. And now he offered the committee a new and different lie, which is that he had released the transcript already. He said, first of all, I'd love my grand jury testimony to be released. I want it made public. And then he said, I wanted the transcript released and I will get it to you, sir, to me. I wanted the transcript released and I will get you the transcript. He said to me, we can confirm that pursuant to my action, that grand jury testimony has been released, the transcript. He said the transcript has been released publicly. He told Senator Booker, well, I don't have the grand jury transcript. That's why I released it. So, as it turns out, no transcript was released. He was making up that lie, probably to get away from having to answer our questions. But now we have an FBI director who first lied in committee about a non-existent court order and had that lie exploded by the actual judge who he claimed had him under court order, and then lied in committee about having released a transcript that we all know has not been released. I think on that state of facts, we're entitled to get the transcript that he says he wants us to have, that he says he released publicly, and that the judge has confirmed is not under any court order of protection. So, Mr. Chairman, I look forward to working with you. I know you have a strong interest in FBI chiefs testifying honestly in this committee and not lying to Congress to try to get to the bottom of what is going on, because those seem like two pretty flagrant and obviously provable lies.
United States Senator stood before his colleagues and accused the FBI director of lying to Congress not once, but twice, with receipts to prove it? That's exactly what Senator Sheldon Whitehouse laid out in a methodical takedown that left no room for interpretation. Senator Whitehouse didn't mince words as he began his remarks. He pointed to something unprecedented in the history of FBI director confirmations. Kash Patel had invoked his Fifth Amendment right against self-incrimination in a legal matter. Whitehouse made it crystal clear what that means. When you plead the Fifth, you're legally required to have a good faith belief that your testimony could expose you to criminal prosecution. As the senator noted, we've never had an FBI director come through this committee who had pleaded the Fifth before. Think about that for a second. The man who now runs the FBI believed his own words could potentially lead to criminal charges against him. The situation got more complicated when Patel eventually received immunity from the government to testify before a grand jury. Naturally, senators wanted to know what was discussed. What could be so serious that it required immunity? But during his confirmation hearing, Patel had a consistent answer whenever pressed about his grand jury testimony. And this is where Senator Whitehouse's concerns really began. According to Whitehouse, Patel told the committee he couldn't share his testimony because of a court order. The senator quoted Patel directly, "There's a court order on that case." Patel specifically cited the D.C. District Chief Judge, telling senators that legal barriers prevented him from discussing his testimony. When Whitehouse pushed harder, Patel challenged him directly, essentially asking if he wanted him to violate a court order. Patel told Senator Booker that the Department of Justice had sealed his grand jury testimony and he wasn't allowed to discuss it. It seemed like a legitimate legal barrier, and as Whitehouse noted, the committee's questions were effectively shut down. But then came the revelation that changed everything. Senator Whitehouse revealed that the D.C. District Chief Judge, the very judge Patel had referenced, issued a clarification in July 2025. Whitehouse quoted the judge directly. Federal Rule of Criminal Procedure 6E allows witnesses like Patel to divulge the contents of their testimony, meaning that nothing was preventing him from doing so before the committee. In plain English, there was no court order preventing Patel from sharing what he'd said. The legal barrier he described simply didn't exist. Whitehouse was blunt in his assessment. It sure looks like he lied about that. But the senator's investigation didn't stop there. He confronted Patel again during recent testimony, and what happened next was even more troubling. This time, according to Whitehouse, Patel offered what the senator called a new and different lie. Patel claimed the transcript had already been released. Whitehouse quoted Patel's own words back to him. "I'd love my grand jury testimony to be released. I want it made public." Patel told Whitehouse directly, "I wanted the transcript released and I will get it to you, sir." He assured the senator that pursuant to his action, the grand jury testimony had been released. He even stated to Senator Booker, "I don't have the grand jury transcript. That's why I released it." Senator Whitehouse's conclusion was damning. As it turns out, no transcript was released. He was making up that lie, probably to get away from having to answer our questions. The senator laid out the timeline clearly. Committee staff looked for it, senators requested it, and nobody could find any evidence that Patel had released his grand jury testimony to anyone. The public release he claimed to have made apparently never happened. Whitehouse summarized the situation with precision. "We now have an FBI director who first lied in committee about a non-existent court order and had that lie exploded by the actual judge who he claimed had him under court order, and then lied in committee about having released a transcript that we all know has not been released." The senator wasn't just making accusations. He was building a case. These weren't matters of foggy memories or different interpretations of complex legal questions. These were specific factual claims that could be verified. Either there was a court order or there wasn't. Either the transcript was released publicly or it wasn't. According to the judge, there was no court order. According to everyone who looked, there was no public transcript. Whitehouse pointed out the broader implications with a sharp observation. The FBI director is responsible for overseeing investigations into perjury and false statements to federal officials. The Bureau regularly prosecutes people for lying to Congress. "I think on that state of facts, we're entitled to get the transcript that he says he wants us to have, that he says he released publicly, and that the judge has confirmed is not under any court order of protection," Whitehouse argued. The senator made his position clear to the committee chairman. "I know you have a strong interest in FBI chiefs testifying honestly in this committee and not lying to Congress." It was a pointed reminder that oversight goes beyond political affiliations. Whitehouse acknowledged these were two pretty flagrant and obviously provable lies, and expressed his intention to work with the chairman to get to the bottom of what happened. His request was straightforward and reasonable. "I don't think it's asking too much to ask committee support to ask Director Patel to do what he says he has already done, which is to release the grand jury transcript of his testimony and provide it to us. If Patel truly wants his testimony made public as he claims, and if there's no court order preventing it, as the judge confirmed, then he should simply release it." What do you think about Senator Whitehouse's findings? Is there a reasonable explanation for these contradictory statements? Or does this represent a serious breach of trust at the highest levels of law enforcement? Drop your thoughts in the comments below, and don't forget to like, subscribe, and share. Accountability matters, regardless of which side of the political aisle you're on.